Congratulations on your invention. So you've done your homework and you've decided to apply for a patent in India because it's a relevant and large market for you. Next, you might be wondering, what do I have to do to not only apply for a patent but also get it granted? The process of applying for and getting a patent is cumulatively referred to as patent prosecution. And there are specially qualified professionals called patent agents who help you to get the patent granted. However, before you approach your patent agent, it's important for you to know what you're getting into. So, without much ado, we now talk about the 10 steps to get a patent granted in India. Step 1. Disclosure. If you engage a patent agent to help you prepare your patent application, you will have to disclose your invention. Prior to that, execute a non-disclosure agreement to safeguard confidentiality. You can explain your invention in the form of an invention disclosure form to help your patent agent understand your invention. In this, you can include diagrams such as a block diagram for a system and a flowchart for a method to explain your invention better. Step 2. Patentability Analysis. First, the invention disclosure has to be checked for subject matter eligibility. If these criteria are satisfied, we then need to check if the invention is novel and inventive. For this, a search has to be carried out to find prior art, which includes published patent applications, granted patents, publications, and any products that are in the public domain. The patent search results can be used to differentiate your invention from the prior art and strengthen your patent application. Anyone can do a keyword search online, but it takes expertise to do a prior art search that gives you advice on novelty and non-obviousness. At MetaEdge IP, we simulate the process that the patent examiner follows to find prior art which affects novelty and non-obviousness, and we prepare the patent application so as to improve your chances of getting a patent grant. Step 3. Patent filing strategy. Once you have your invention disclosure and patentability search report, a skilled patent agent should be able to advise you not only on patentability but on what type of application to file. This should take into account the amount of detail in the invention disclosure, whether patentability criteria are met, the timelines for commercial activity, as well as budgeting. You can either file a provisional patent application or a complete patent application. A provisional patent application is particularly helpful if your invention is in the concept or experimentation stage. You can get your patent filing date or patent pending status at the earliest, and you have 12 months to further improve on your product and then file the complete patent application. Step 4. Drafting the patent application. This is a step that is best done by patent professionals. A good patent draft not only requires technical know-how but legal expertise. A good patent draft will not only help you to get your patent granted but make it almost impossible for your competitors to design around or reverse engineer your patent. Step 5. Filing. Upon completion of the patent draft and approval by the inventors, the patent application has to be filed with the Indian Patent Office. Along with that, you have to submit a proof of right which is signed by the inventors and a power of attorney that authorizes the patent agent to represent you. The patent application is filed electronically with the e-filing portal of the Patent Office and digitally signed using an e-token. Step 6. Publication. Once the patent application is filed, the Patent Office will typically take 18 months to publish the patent application. However, this period can be shortened to just 1 month by filing a request for early publication. This is important because only once the patent is published and a request for examination is filed will the patent application be placed in the queue for examination. And once the request for examination is filed, it can take 2 or 3 years for the Patent Office to issue the first examination report. However, this can be shortened to just 6 to 8 months by filing a request for expedited examination. Step 7. Examination. The Patent Office will conduct a search and issue an examination report with objections on the basis of novelty, inventive step, and subject matter considerations. We have to prepare a response that addresses and overcomes all these objections in the response to the first examination report. Step 8. Hearing. After reviewing the response to the first examination report, the controller will typically do an additional search and issue a hearing notice. The hearing gives the applicant an opportunity to have a video conference with the controller explain the invention, the differences over the prior art, and address and overcome the objections raised in the hearing notice. A written response has to be submitted within 2 weeks of the hearing. Step 9. Grant. If the controller is satisfied with the response to the hearing notice, the patentability criteria are met, the patent will be granted and it will be published in the Patent Office Journal. Step 10. Renewal. The patent has a term of 20 years from the date of filing. Once the patent is granted, it has to be renewed by paying a renewal fee every year from the 3rd year onwards. If you fail to pay the renewal fee on time, your patent rights will lapse. We at MetaEdge IP appreciate the value a granted patent adds to your venture. Over a period of 15 years, we have worked with hundreds of innovators and startups and seen them grow leaps and bounds by building a portfolio of granted patents. If you want to get on board this journey to convert your valuable idea into an intangible asset, drop us an email to ip@myipstrategy.com.